Hi, everyone. We are jumping on this morning. Sorry we weren't live last night. I saw that a lot of people were still in the chat and watching, which was, oh shit, sorry. Sorry, I have our YouTube on and then I realized that it's echoey. But yeah, sorry we were not live. I had something to do, which is also why we have the breaking news that we had at the moment. But as the day progressed, a few more documents and motions were released. And hey, Taryn, I'm going to pull those up right now because this is a pretty big deal. Jarrett, would you agree?
Very significant developments in Oklahoma. We'll talk about each one. These are the kind of things that we have been telegraphing and were somewhat expected, but it looks like it's happening. Essentially, Paul Grice has waived his preliminary hearing. He's waived his right to a speedy trial. Those two developments, say to me that more than ever, he is very likely participating with the state and will be a witness for the state. I mean, he's basically saying, I'm not going to challenge at the preliminary level. And I agree that the state does not have to bring me to trial within a year. So that is a cooperative effort between the state and a defendant. And the fact that he is now moving on, will not have his preliminary hearing with the other four, is a significant development. The question still remains, will he be in the witness chair at the preliminary hearing? That's not clear yet. But
okay, so this is it right now. I'm just throwing this up. While you go through this, I'm just going to throw this up on Facebook.
Sure. So that's the waiver of the preliminary examination. You could see it's signed by the district attorney's office, Paul Grice, and his attorneys. So this is a cooperative effort. The document's signed. He's waived his preliminary hearing. It was filed on September 18th. He's saying, I acknowledge I have the right to challenge these charges before a magistrate judge. I am going forward and not challenging those charges at this time. In all likelihood, there is, and this is not confirmed yet, there is a plea agreement with Paul Grice to plead guilty and to testify against the Tad Collum, Tiffany Adams, and the Twombleys. Big development. Huge. Now you have an eyewitness to corroborate the DNA, the findings, and all of the evidence we have had to date. This was exactly what we were hoping for on behalf of the victims, if that happens. And in shoring up your prosecution, you now have one less defendant to worry about prosecuting. Now it's a married couple and another couple who was together, Tiffany and Tad. Again, this is a significant development. It is a real, I would say, feather in the cap of the prosecution. We had speculated early on that this may be going because Paul was charged later.
Yes.
But
so,
again,
Jarrett, do you think that at this point, and you kind of said this, but it's Paul's like, okay, look, I don't want to be a part of this at all. I'll tell you everything. I'll take life in prison. Just, I don't want to deal with this.
Yes,
and
that's absolutely what could be happening.
Okay. Wow.
Now, you also sent me something else. Was he transferred?
Let me see. I think so. Hold on. Let me remove that. Well, first of all, hold on. Can we show the speedy trial one too, just because that's so interesting?
Sure.
And you can just break that down for a minute. Thank you. Hold on. Sorry, I'm moving so fast.
That's okay. I mean, it's like I said, we've been on top of this thing. This is a significant development, and for the folks that watch from Texas County, and we know there are some, and the folks that have been passionate about this case, this is a very, very big day. I mean, it looks to me, and again, we're yet to be confirmed, that all of the pieces are starting to fall into place. So what he's doing by waiving that speedy trial is saying,
Did I show you the preliminary or the speedy trial? I forget now.
The preliminary.
Okay, now here's the trial. Okay, got it. Thank you.
So in the state of Oklahoma, you have 1 year to bring someone to trial. Okay. That is, of course, if that individual doesn't cause any delay on their end. So when you agree with the state that we're going to waive that right to a speedy trial, the DA is no longer under the gun of getting your case in within a year. That is a cooperative effort. It's kind of letting the air out of some pressure that the DA may be feeling to move a case along. So that is typical of a defendant who is going to testify, because their case won't be resolved. His plea may not be taken until after he testifies. So we're talking much longer than a year. So part of his deal is he's got to waive the right to a speedy trial so he can't challenge that down the road. That's why this document is important.
Oh my goodness. Wow. 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 And yes, it looks like, hold on, let me send my screenshot, because Dizzy, yeah, it looks like he was moved. And Jarrett, he was most likely moved for his safety, I'm guessing, if he
Yes, I think it's pretty clear. He was moved out of the jail that holds the other 4 now, because it is clear he's shown his cards. He is a witness for the state.
Wow.
Again, I'm speculating, but it's, these are the things you're looking for. These are the things I've done. Certainly in my career, when I have an individual that a co-defendant in a murder that's testifying, I move them for their safety. I move them so they cannot be compromised in any way by being in the same facility with their co-defendant. I waive their right to a speedy trial, and they waive their right to a preliminary hearing.
So the preliminary hearing in December, do you think it's likely that Paul Grice is on the stand for that? Well,
that remains to be seen. Do they save Paul for trial? I don't know. That's really up to the DA. I mean, there was they were ready to move forward with Paul in the defense chair. So whether or not he now graduates to the witness chair for the prelim, that's really a prosecutorial decision that has to be made. Why you may see him in the chair is because you lock him in. He then loses the ability to kind of change his mind. It's too late to go back. That testimony is in, it's documented. Everybody has a full and fair opportunity to cross-examine Paul. I'm going to tell you something else that is worth considering. I've had witnesses whose lives I feared were in danger testify to lock in their testimony and to say to a would-be defendant, if you had any inclination to harm this individual, it's too late. Their testimony's already locked in. So there is a chance you could see him. If you don't be shocked. Doesn't mean he's not going to be part of it.
Okay. I'm just dizzy. I just asked you, my screenshot's not uploading. If you're able to quickly find that link, that would be amazing for me. And then I'll share it just so everyone else can see. I don't know why. Maybe I'm just slow on this and you can't share images or something. But okay. So either way, Paul will most likely either A, not be at the pretrial hearing at all in December, or B, possibly be used as a witness per these documents. Half speculation, I guess, Jarrett, right?
It's more likely than not. As I'm processing this, he will testify. Yeah. He will at the preliminary hearing, provided he is a witness, all those caveats. But if he does not, I would not read too much into that either. I would think they're saving him for trial. I've seen it done both ways. With the amount of moving parts in this particular case, if I was prosecuting it, Paul would be on that stand. He'd be called first.
Oh, really?
Yes, absolutely.
So do you want to read what Taryn said?
Yes. So good point. Taryn is playing devil's advocate. Sometimes co-defendants are moved because the current facility doesn't have the capability to keep them separated. That's true, but they've been in that facility since they were arrested, Taryn. So I think we're making the same point. So if you're saying he may have just been moved for the purpose and the simple fact that they could not keep those folks separated, they have all been in that facility together since they were arrested. Here's the thing you have to think about. Also filed the day he was moved was the waiver of the speedy trial and the waiver of a preliminary hearing. So those two things are very coincidental that they would be filed on the same day he's moved. That's why we're concluding. Devil's advocate, though, there are entirely other reasons Paul could be moved. There are reasons other than him testifying. So it's a good point.
And then here is the, sorry, I had to pin that. I thought that was funny. first one to squeal gets the best deal.
Let
me share this.
Good point. I think if that's what's going on, I don't know how good the deal is going to be here, though. That remains to be seen too. If he's actually agreed to testify.
I mean, Jarrett, could the deal include obviously no capital punishment, let's say, and possibly a better prison, maybe where he could be near his family or something? Would he kind of throw that in there? Is that something that they would be able to do?
The DAs can recommend something like that. It could be part of a deal. Oftentimes, judges don't have jurisdiction to place someone in a particular facility. So you would have to have, and I've done this, you would have to have the Department of Corrections of Oklahoma involved in that conversation to the extent they can be. But it's worth noting, if he is a witness, there are certain considerations that have to be made with his ultimate placement once he finds himself in that state correctional institute. Right now, they're in the county facility. So what we're talking about is his permanent placement in the prison as opposed to the jail.
Okay. Yeah. Right. That's I guess what I was getting at. Like, because there's no way this guy is going to, I mean, God, can you imagine they're like 25 years? That would never happen. Never.
Never say never. I don't know what the offer is.
You're right. No, you're right.
I could bet, though, looking at the evidence they have in this case, they weren't desperate for Paul, but it certainly solidifies their case. So, it's a give and take. You balance the need for this particular person and the fact that you're taking a defendant off the playing field versus justice. What's fair? I mean, we have two innocent victims here. So, again, it remains to be seen what Paul's actual role is. I know what was in the last pleading that we reviewed. He had an active role. So knowing that he was more of a principal than an accomplice, in all likelihood, they've pulled death off the table. I wouldn't be shocked if they said, hey, there's the possibility of a parole application down the road. Again, there's no guarantee. And looking at this, I can't see a parole board that would consider paroling him even after 30 or 40 years.
Well, Forrest, I get what you're saying. The other four are the most culpable, and they're the real stinkers. I mean, I have to wonder, Jarrett, do you also think they might have some kind of I don't know how I should put this. I mean, Paul Grice is not insane. He's not crazy, but perhaps he might be, I don't want to say on the spectrum, or like he might have a learning disability or something where he is easily persuaded, and they might just paint him as like, well, he has the muscles because he's, this bigger man with muscles. So he was the one that would probably be the most effective in actually going through with how one of the women died. Do you think they would kind of say, well, he's not in his right mind. He's got some problems. His IQ is XYZ.
Those problems are going to bite you if he's your witness then. I mean, those problems that may create him and make him a more sympathetic defendant in this situation, I don't see that happening. But
I guess that's why I'm confused. I don't know.
I think those concerns would get, I believe they looked for somebody who can come to the table. One thing is the Twombleys are married. Okay. Yeah. One of them is not likely to come. You run into a marital privilege there. You're either getting both of them or none. Although Cora fought against a joint preliminary hearing where her husband was okay with it. So but again, you're not going to get Tiffany without Tad. You're not going to get the Twombleys without each other. Paul, as we said, was the weakest link. You're going to get, if you need to flip one, you flip one. It virtually guarantees a much stronger case for the prosecution. I would love to say it guarantees a conviction. It's good, but for the victims' families and the folks close to this case that watch, this is good news. This is good news. Okay. So know that the state's working really hard. They have a witness, and this, provided that's the case, that if all other things being correct and accurate as we're looking at it, if Paul is in fact going to testify, this is good news. The path to conviction has become clearer.
So this might be a better way to phrase it. Sheila said it, I think, better than I did. he's vulnerable. Jared, if he's vulnerable to do these things, that doesn't make him any less credible of a witness, does it?
Well, if he's impressionable, as a defense lawyer, I would say the power of suggestion, the power of luring him to testify, the fact that he could lie, all of that makes him less of a credible witness. The fact that he's vulnerable and susceptible to influence of people like Tiffany and would act out and commit these crimes, yeah, I mean, that's important. But the bottom line is he's not insane. His IQ, at least as far as we've seen, he wrote that letter about sovereign immunity and all those things. Like, that's not someone who's incapable of understanding if I stick a knife in somebody, they're going to get hurt and die. If I throw their body in a hole, I'm going to be held responsible. So whether or not he's as cunning and is a little bit more impressionable than Tad or Cora, I mean, that may be the case, but it's not going to make him any less culpable in the ultimate, assessment of the case. So.
Right. But maybe the state also identified him as possibly the most vulnerable and the most easily persuaded. And then they zeroed in on him from the start. I don't know. That was just a thought.
Well, I think so. I mean, but I've seen very, very smart people, not impressionable, take a deal because they recognize the strength of a particular prosecution. They were pursuing their own vendetta against their co-defendants because they were pissed off. So you really never know what's going to appeal to someone. As we said, I'd go to the Twombly's if I couldn't get Paul. I'd go to the Twombly's and say, if you care about your child, what are we doing?
Yeah.
So, but again, I'm not there. I mean, obviously, you and I have been following this thing, and our viewers and listeners have certainly been. I'm only saying what I've seen, and I would be speculating, and I don't want to do that about what the DAs are doing. I think they're doing a really, really good job so far of moving this case along.
Now, let me ask you, before regular trials or before a trial is going to move forward, usually there is a witness list. So, or for both sides. For the pre-trial, do you think we're going to be able to access that before? Or not for a pre-trial?
No, typically that wouldn't be filed. What would happen, though, is as you arrive at that proceeding or shortly before, you would give the key to those proceedings. This is a little bit of inside baseball, but one of the things, if something happened to your witness in between the preliminary hearing and the actual trial, let's say a witness has died, and I've had this happen. If you give the other side that witness's prior record and the reports related to that witness, you can say to the court down the road, they had what's called a full and fair opportunity to cross-examine them. They got to test their criminal record. They got to review the reports and understand where they fit into the presentation. So in the event that person was unavailable or died before the trial, their testimony can be read into the record. And I've had it happen more than once.
Wow. Okay. But like you said, it's safe to say, Paul or no Paul, this case would still be fine and move forward with a lot of damning evidence so far from what we've seen.
Yes, the case is very strong, but with Paul, it got stronger.
Wow. That is so crazy. Oh my gosh. I am happy for the families at this point that, he was able to work this out with law enforcement.
If that's happening.
Yeah, if it's happening. I mean, I think it all makes sense. I think from the beginning here, the fact that he wasn't arrested right away and we're all like, oh my gosh, it all makes sense. From the beginning, he was like, I'll tell you everything. This guy doesn't want to die. I mean, I think that.
And we kind of recognize that. And again, you don't need to be an expert in this business to understand 4 prosecutions is better than 5.
Yeah, so true. And like we discussed yesterday, just a little bit, what if they end up splitting 2 and 2? That would be even better for everybody. And now it seems almost more attainable, right? Or am I wrong?
No, I think it may be. As their defenses become clearer and their lawyers take their respective positions, I think that may rear its head, but it still remains to be seen. I'd be fighting all tooth and nail to keep them all 4 together as they are right now.
Oh, you would. Okay. Got it.
Until I see something that.
Thanks for joining us. So, okay, so you would still fight to keep all 4 of them together.
Oh yeah, and unless something dramatically changes where you kind of fall on the sword and say, well, clearly their defenses are antagonistic at this point, Judge. I'm not going to insult you with that argument.
Yeah. I was actually thinking about this too, Jarrett. Are we going to, for the pretrial hearing, is that when we are going to really find out what each defendant is using for their defense or what they're going with here?
No, they don't have to say a word at that hearing. You may be able to parse it out based on the questions their lawyers ask.
Yeah.
But they're not required. They're never required to put on a defense. But you may be able to glean their strategy from the cross-examinations, but they could say nothing at that hearing. They could literally sit on their hands. So we're going to find the details of the crime out that we don't know right now, but you are not necessarily going to find out what the defense for each defendant is necessarily. You may, but it's not a guarantee.
And let me ask you this. Do you think it's possible, and I know you said anything is possible, they could sit there and do nothing, but do you think it's possible, let's say, for Tiffany's side to call in a counselor that Veronica's kids worked with and have them say something that would be damning towards, I guess, Veronica or her family?
Not at this stage. They have the right to call witnesses, but somebody that far afield to the actual crime itself, you wouldn't typically hear from somebody like that at a preliminary hearing. That may come down the road after. So for me, if I got that, I'd be like fighting. I'd want to proffer on that witness. I'd want to know why their testimony is relevant. All of that. So at a preliminary hearing, you wouldn't see that.
And do they have to submit their witnesses well in advance, just like you would for a regular trial?
For the prelim?
Yeah.
No.
Not at all.
They're not required to provide any advance notice. That's why the one thing they're required to provide is that information I said. They could show up there and say, hey, we're calling Paul Grice. Here's his prior record.
And that's it.
That's it.
So it's like free for all, pretty much.
Oh, yes.
Oh, that's so. I don't think I realized that.
It's you don't know what the prosecution is gonna who or what the prosecution is gonna put on,
or the defense, right?
Right, and they don't have to put on anything. The prosecution has to put on stuff.
Yeah, right, because that's their job to prove why they're able to meet their burden of proof and why these people are guilty. So, okay, this is so interesting to me. I think this is really good. Hopefully, if it's what we think it is, and Paul flipped. Yep. Youngest, I guess, has the most children that are still young and that probably need, a wife that probably needs money to support these said children. I guess this would make the most sense here. Does anybody have any other questions? I think we covered this major development, but if there's any more, like I said, we'll try to keep you updated as best we can. I wish I had this last night. I'm sorry. I was tied up, but I think everybody in the chat seems to be good. All right, guys. Thanks for tuning in. Share this video, like it. Make sure if you are in touch with anyone who might be close to the case and they want to know what's going on. Jarrett did a phenomenal job of explaining and breaking it down for lay people like me and like some of you. So, all right. And I
share our show and tell people these guys are right about a lot of stuff. At least so far.
Yeah.
Thanks.
So far, we're right until we're not right.
That's right. We'll acknowledge it. So
yeah, totally. And Sheila, you are so welcome. I'll try to throw up some of these documents on X as well. All right. I will talk to everyone later. Bye.
Thanks, Lauren. See you later.